The Supreme Court also struck down President Biden's student loan forgiveness plan. The High Court, in a 6-3 decision, ruled that the Biden administration overstepped its authority in trying to cancel or reduce student loans for millions of Americans. That decision effectively killed the $400 billion plan that President Biden announced last year. 40 million Americans stood to have up to $20,000 in student debt wiped away under the plan. Repayments are supposed to resume by late summer. And the court held that the administration needs congressional endorsement before undertaking such a costly program and rejected arguments that a bipartisan 2003 law dealing with student loans provided the authority Biden claimed. To explain this further, we've asked Professor Ken Katkin, Northern Kentucky University Chase College of Law professor. He joins us now. Thank you so much for being with us, Professor Katkin. What does this mean for students who still have loans for their education outstanding and we're hoping for relief?
Well, it depends on their situation, but for most of those students, it probably means they're going to have to pay the loans. There are still a number of other student loan forgiveness programs that were not affected by today's decision. So for students that are in low-income jobs or unemployed or in public service jobs, they may be able to avail themselves of different debt relief programs, but there won't be the blanket relief that this order, the Biden order, would have given. Right.
Now, explain this ruling. Is the court saying only Congress can make such a financial decision?
Yes. I mean, I think both the Biden administration and the court actually agreed that only Congress can make such a decision. But the administration argued that Congress had already made that decision, that in a 20-year-old statute that Congress enacted in the year 2003, that Congress had already given the Department of Education authority to waive or modify student loans in response to national emergencies. And that because of the COVID emergency, that was the authority being invoked. The court didn't agree with that, though.
Right. That was the HEROES Act that the president was kind of basing, or the administration was basing their argument on. You know, one thing that seems to be lost in all this, I know you call this a blanket forgiveness, but, you know, it's really only, we're talking up to $20,000 for Pell Grants and then $10,000 for, I think, people making up to $125,000 a year. Many are saying the court is politicizing this issue, including the dissenting judge, Justice Elena Kagan. She said the conservative justices overreached, putting politics ahead of case law. Is that a fair argument?
Yeah, you know, I think it is a fair argument, but I think there's a fair counter argument also. You know, there was necessarily going to be a lot of politics in this decision precisely because the legal question was a very close one. You know, you have a statute here where the language of the statute did seem to support President Biden's order, but President Biden's order went very, very, very far beyond how that statute had ever been used before. And so I think, you know, when you have such a close legal question, it's not surprising that all the justices who are in the same political party as the president sided with the president, and all the justices who are in the opposing political party sided against the president.
Yeah, we're seeing more and more of that for sure. Now, you know, I know standing was an issue in this case. In fact, another challenge to loan forgiveness was dismissed due to standing. Explain what that means, standing. And how did Missouri, who brought the case before the court, have standing in this case when it was a public corporation that would really experience the loss from that loan forgiveness, not the state of Missouri?
Yeah, so the issue of standing is the idea that there may be a lot of people in the country at any given time who don't agree with some action that the government has taken or some policy that the government has implemented. And simply disagreeing with what the government is doing is not a basis for bringing a lawsuit. A person who disagrees with the government action generally does not have standing. To have standing, you have to have a plaintiff who themselves can show that they've suffered a particularized injury in fact, and not just the generalized grievance of disagreeing with what the government's doing. So in this case, there were actually many plaintiffs, and almost none of the plaintiffs had standing. The court actually issued 2 opinions today, and in the other opinion, they explained all the reasons that most of the plaintiffs didn't have standing. The one plaintiff that had standing was the state of Missouri. The state of Missouri was found to have standing because there's a state-created, state government-owned corporation called Mohila, which is a corporation, but it's a state government corporation, and it plays a role in processing student loan payments from student debtors from Missouri, and it does have contracts with the U.S. Department of Education where it receives a small fee for every transaction that it processes. So Missouri's argument was that if a number of debts are forgiven and therefore fewer monthly student debt payments are collected because a lot of debtors suddenly don't have to pay any anymore, some just still have to pay but not as many, then that means that each check that would have come in each month, that transaction fee will no longer be collected by the state agency.
Right.
So the state will lose all that money, and that was the basis for standing.
Right, so it would be detrimental to Missouri. All right, wow, you did clear it up for us. Thank you so much. Professor Ken Katkin of the Northern Kentucky University School of Law, thank you so much for joining us. We appreciate the time.
Thanks for having me.